Meeting at 11 a.m. today, and just a quick reintroduction of the guests that we have in studio this morning. I have Dr. Alutulala Mkhwana and Collins Mango Martin Olo, who are lawyers. And gentlemen, you've given glowing tributes to what has happened so far to the Supreme Court in terms of handling what they have before them. Also, a more organized team from both the petitioner and the respondents, dividing their time, but also working with very, very strict time frames. Given that we only have 3 days and a ruling has to be given based on how they manage their time. Let me start with you, Dr. Mkhwana, on what is expected now today. Once we get to today, and also maybe just to highlight the importance of the access that NASA was given to the IEBC servers and how that could play out today.
Thank you, Michael. First, with the importance of the access that was granted, I think it was very, very important, in line with what I said in my introductory remarks, that what the Supreme Court has done is really to grant all the parties their wish, within the law, of course, and with their discretion, access to the digital platform of IBC, to the servers, is critical because that is the anchor on which NASA's case is predicated. That look, yes, we have problems with some of the 34Bs, but look, the main problem was in the servers, that the transmission was faulty. In fact, they have, some of the council yesterday said, look, the transmission, the technology failed. So in my view, the access that was granted was a super move. It was a good move by the court. It also settles NASA's agitation, because if NASA's feeling was that if we are not allowed to access the servers, then our case is dead on arrival. So in my view, that was a fantastic decision by the Supreme Court, and it is also a good thing for the NASA lawyers.
All right, Martin, looking at where we were, according to the law, the Form 34Bs physically were to be taken to Bomas. Why the need for the access to the server? Maybe just to break that down for us to understand. Because one would imagine with the physical forms, that should be able to give us the numbers.
There is a dispute around the nature of Form 34As. Less on 34B and even less on 34C. Are the forms that were used to construct 34B genuine? And so the difference is going to be in terms of the ability for the petitioner to demonstrate that there is a sizable number of those forms that were not genuine, and that there is alteration around 34A that then requires the court to scrutinize the eventual tallying in 34B. So there is room for that. Now, what is the petitioner's case when they are looking at the server? Basically what they are saying is that the information that was keyed in is different from the information that is in the 34As. And should they be able to make that case, then certainly we'll see the difference between what is being hosted in the server and what is in 34A. This assumes that nobody has realized that and has made that change. That's why the court in ordering is very clear about the period. It says between 5th August and 11th, up to the 11th.
Yes.
So what they are saying there is that in the event of anything, that should also be picked, including the log records and the details of whoever has gone in there. So the key issue here is for the petitioner to prove that indeed there is the difference between what is in the server and what is in 34A, and if there is any attempt to reconcile those two, those attempts have been done subsequently to then match 34A. Now that is what has to be proved. It is a statement, it's an allegation from where they are. Of course, IEBC in responding says this is a wild goose chase. The truth is going to come out of the report that we shall see and the submissions on those reports. But the clear issue here for me, what I think is going to happen, regardless of what the outcome of this Supreme Court decision is, the clear issue for me is, did IEBC perform its function beyond reproach? Were they like Caesar's wife? Can we find that they could have, they actually, because a lot of things that are being alleged go back to IEBC. not to the players. I mean, the third respondent, the president, was participating in this game. There was a referee. The question is, did this referee do a good job? And I think that's where the whole of this petition is lying. So that when Collins says that what the petitioner is trying to say, that they were not properly conducted, they were not done according to the law, and so on, that is a serious issue. Remember, there was a court of appeal ruling, a high court, and then a court of appeal upheld it, which essentially detailed out the manner in which the electoral processes were supposed to be managed, especially between the electronic and then the manual, the transmission, and so on. Remember, there were two elements to these elections that were electronic: the identification process and the transmission process. Now, in between, did the manual processes complement or distort?
Compromise.
Or compromise. That's the challenge.
All right, Collins, and as you come in, there are several things here that we'd like to look at. Now, the petitioner is trying to prove something.
Yes.
And there is the notion that the elections may not have been, according to the petitioner, may not have been free, fair, and transparent. However, there's also the question of whether that really affects the numbers at the end of the day, because there's the argument as to whether elections are won because of the process, or are they won at the end of the day because of the numbers. And after all is said and done, if the process is questionable, does that affect the numbers to the point where it actually now means that we cannot clearly say that this is the winner, regardless of whether it is the president, the current president, or it is Raila Odinga?
Yes, thank you very much, Michael. I'll put your question on hold just for a minute to go back a little bit on the electronic and manual aspect. Now, you could find yesterday IEBC through their councils, they were trying to argue that the system is more of a manual than the electronic, and they were terming the results that were being transmitted as statistics. And the law says that the system is manual but with electronic backing. So that is something that IEBC was trying to evade in terms of accountability to what was being transmitted, because when we go back to now the election day process, the thing was the results after being counted were to be filled in the Form 34As, scanned and transmitted. So NASA was arguing that those forms that were transmitted, compared to the physical forms that have been brought before the Honorable Court, there are some variances. And you could even remember they were arguing that if you could scan some of those photos, they were bringing very funny organizations. And these are things that came from the printing firm, packed, sealed, and they were specific as to the even polling station.
But in all that, the petitioner is trying to prove that there are so many discrepancies that would now give us a result that we cannot depend on.
Now, back to your question on the threshold. And you could remember it was also a big point of argument. And Senior Counsel Orengo was first, Paul Mwangi, talked about it being a civil case, and that the standard of proof should not be very high. Civil cases, as per common law practice, is that the standard of proof is at a balance of probability. But in 2013, the Supreme Court set it at a slightly above balance of probability and slightly below reasonable doubt. That notwithstanding, this case, Orengo on his submissions was challenging. Okay, the NASA petition are really not challenging the victory or the announcement of Uhuru Kenyatta as president, but they are saying, look, wait a minute. These elections were not held as per the set guidelines and principles of the Constitution. So they are not more on the numbers, they are not more on the significance of Uhuru's victory. And Orengo was also talking of 50+1. He was saying that, and this is where also the rejected votes come in. And also another thing that we'll be keen to see is how the court will this time round also, because this is an issue they have also been interpreted. They have been called upon to interpret. And in the doctrine of stare decisis, the Supreme Court is also not held with decisions from lower courts. So this is something that we'll be keen to see. So the arguments from the petitioner on things to do with the rejected votes, this is a very big factor if you are looking at 50+1 vote.
Michael, if you allow me to just add a little bit to what my colleague is saying, I think if you listen carefully to the first respondent, that is the IBC, the second respondent, they are actually admitting that indeed there were errors.
Yes.
In fact, they are saying, for instance, that particular case of Rarieda, where Raila received no vote, Nyando, thank you, they are saying, yes, that
is an error.
Indeed happened, is an error. Then the other cases cited say, indeed, that is an error. And another one, indeed, that's an error. But look, it is not meaningful. It is
In other words, it may not, despite all those errors being put together, they may not affect the final result to a point where we need to, there's 50+1.
Thank you. Apart from 50+1, they are saying, look, yes, these are administrative errors, those are statistical, that's counting, but it is not so substantive as to affect the final result. So the onus on the petitioner is to prove that, look, hey, these are not just errors. In fact, they were deliberate, they were premeditated, they were planned, they were organized.
Yes.
So much so that we are unable to tell who won this election. And therefore, my lords, this election must be declared null and void so that Kenyans go back
to the ballot.
To the ballot in line with Article 1, which gives sovereignty to the people of Kenya. So in my view, this case will stand and fall on is what the IEBC calling errors big enough, substantive enough to warrant what the petition is saying, that look, because of those errors, what you're calling errors, it is impossible.
We cannot tell who won the election.
We can't tell. We can tell.
All right, Martin Olo.
Yes.
How does that affect the rest of the election? Because here we are concentrating on the presidential election. But if these errors indeed are proved to be errors that were premeditated, thought about to a point where they favored certain candidates, then how does that affect the rest of the candidates, because they were under the same system? We didn't have a different system that was, working for them.
It might give whoever wants to petition some grounds to use. But remember, if you haven't complained about your election, and if you have not raised enough grounds about your opponent's win or something, then there's nothing that will be done. The results that have been declared will remain so. So it will take those who are in court to use whatever outcome of this Supreme Court will be to apply to theirs, if at all. Because I'm saying if at all, because when we talk about 34A and 34B and 34C, it was in respect of presidential elections. We had more than 5 other, we had other 5 elections. The governor, senator, women rep, MCA, member of National Assembly. So it does not necessarily apply that in respect of 34A and the mistakes, those could also have been reflected on the other one. So it will be a bit difficult to carry this and apply it there. But if it is said that generally the management or the conduct of election was so bad that it's difficult to say who a winner is, that could give an ammunition to any litigant or any petitioner or any advocate on the other end to actually use it. But I doubt that you'll have such a blanket proviso that will then apply across everything. Though initially, if you recall, when the petitioner was beginning to put his issues together, he almost said that everything else down was, but you see, even that argument could not be prosecuted in terms of the Supreme Court, because you cannot go to Supreme Court on all these other issues other than on the presidential election. So we have a challenge there. My only sense is that we get better every time, because remember that it took a very bad decision from the Supreme Court last time for us to improve or even on the electoral system. I believe that this time round we'll get even much more, course, we'll get some more information or some more directions that will help us improve our electoral process.
Dr. Mukhwana, you wanted to add something?
Yes, I wanted to add what my learned senior is saying, that look, it may not give the governors and everybody else down there a blanket check with which to rush to court. But it does lend credibility. If indeed it's upheld by the Supreme Court, it will lend credibility to the fact that, look, if this indeed happened, then it is possible that the entire election was mad. Now, Michael, what interests me, which you haven't mentioned, is the claim by the petitioner about the formula that Council Otiende displayed it, that all you need, and I'm not a mathematician, but I really hope that they are right on this one, that using that formula, all you need is to take any vote that Honorable Raila got. And using that formula, you'll get precisely the number of votes that Honorable Uhuru was given. If they did their homework correct, and if indeed once the judges retreat to their chambers, they apply at random
the formula,
then that might be a very interesting result. The second point...
just on that,
yes,
I don't think it's for the judges to apply that formula. It's for the petitioner. And I believe that even as they look at the server and other information, it's for them to canvass that issue and make it in a submission so that the judges can then be persuaded.
They have.
Because I'm saying that's where the strength is, so that what the judges ought to do now is to be convinced of that formula. In other words, that they should, if it's not countered well enough by the respondents, then it's on record, and they may be persuaded to go with it. But it's an important point, especially when you can corroborate it with the information from the servers.
And I guess that brings in also the aspect of what maybe we are learning in this particular petition, the need for technical support, as it were. Because like you rightly said, you may not be a mathematician, and maybe even the 7 judges, that's not their strong point. So they will need some technical... Collins, the learning that we're getting from this, again, remember even when NASA had requested to access the server, there was the question of how long will this take? Technically speaking, the judges may not be in a position to actually make a ruling and know this is how long it takes. But how we are learning the amount of support possibly needed even in a petition like this.
Now, also this petition is bringing in a new aspect, and it's a challenge now for us lawyers. It's now bringing the place of IT in modern law, and this is something that we now need to learn from the bench to the lawyers, to the bar. This is something new, this is a new development, and you saw there was also a lot of challenges, them trying to understand what exactly it means to access the system. What exactly will they get from the system? So this is something new that we are developing in our laws, which is very good. Now, just to bring it back also on the issue of, they were discussing on the impact of this petition on other elections. For me, I tend to disagree and say it has a bearing in a lot of petitions. One, they're questioning the integrity of the Independent Electoral and Boundaries Commission. So if this is a major ground, if you look at the 28 list of issues from the petitioners. So this is something that anyone can say and can go to the court and say, look, these people, their integrity was checked and they were found to have held an election that was not of integrity. Apart from that, there are a number of issues that also might have a bearing on other petitions, things to do with the burden of proof. And you saw this was really, really argued yesterday, where counsel was saying, as a petitioner, once I allege and bring some of the evidence, now it is upon the respondent to prove that this thing was fair, the process was okay. So these are some of the things that we are going to see in other petitions. And apart from the Form 34As that might not apply, you see also those other positions had their statutory forms. The governor had the Form 37A. So these are also some of the things they will also be challenging and saying, is this statutory form, does it have the security features? You remember they were talking of the security features. Were they verifiable when they were talking of the stamping of those forms? So these are some of the things that will have a very big impact, not forgetting the rejected votes. This is also a very big bone of contention that we'll wait for the honorable bench to see what they'll also decide on.
Right. Martin Olo, as we get closer and closer to an end, what we should expect today? There's, of course, a lot. We know they're starting at 11. There is that report that we're expecting that NASA had access to the servers and are coming with that report, which, like you've mentioned, is the fulcrum and almost the foundation of the whole case of proving that the elections were not held in a fair and free manner. So what we should expect?
Michael, if you allow me, Senior, I think the question you asked my learned colleague, the backup that the Supreme Court requires, clearly they are at liberty to consult the best expert they can come across. That is for sure. Because if you read the decision that they made in terms of the access, they were very particular. Read only. Read only. You and I, who are not ICT experts, would not know what read only is. So that tells you that the Supreme Court judges have had a lot of expertise behind them.
And they have consulted.
And they have consulted. Thank you. That's just what I want to clarify.
All right.
Perfect. I think we are building up a case for more technologically savvy lawyering. And this is not a question of a distance. And every time you come to the legal profession with some other background, whether it's medicine, whether it's technology, whether it is, whatever it is, the chemist, whether you're a chemist or a biologist, you enrich the legal profession, especially if you are going to work on areas of forensic evidence and so on. So basically what we are seeing in this particular case is that going forward, lawyering will require that we have a better grasp of technology and some understanding of language, such as
more reading,
such as logging in, algorithms and so on. So there will be some logarithms. We go away the better as a legal profession, trying to now understand a few things. That said, I think that today we are looking at almost the final day where we will be hearing more in terms of the interested parties, the amicus curiae, and all other submissions. Remember, the role of amicus curiae is to help the court consider certain issues that may have not been canvassed by any of the parties, or even if they were being canvassed issues, and helping the judges to see certain things. This is a point at which if there's any lacuna or any gap that has been left between the petitioners and their respondents,
bring it to
the friends of the court are helping the court to surface those issues, to weigh them, and see the extent to which they can influence how they think and how they make decisions. We expect that when all is said and done, there will be some responses that will be coming in from the petitioner, because then some of the grounds raised by IBC, some of the grounds raised by other respondents will allow perhaps a few minutes from the bench, allowing the petitioner to respond to some of those things, so that they can again tie up their case. Beyond today, and apart from written submissions and any reports that will be submitted in, the bench will be retiring to the chambers to consider and to reason out their decision, so that when they emerge on Friday, actually they seem to be having a lot of time. When they emerge on Friday, they should be able to give us something so
something concrete.
Something
all right,
so concrete.
Gentlemen, we'll have to wind up, and maybe just very, very brief closing remarks, Collins.
Yes, today, we are going to hear the amicus case, and remember that there's also a very big bone of contention as regards Section 83 of the Elections Act, where the Law Society of Kenya has been asked to come in and help the court interpret as regards non-compliance. So that is something that we are going to hear about today, which was really argued out. We also want to hear from the respondent. A lot of allegations have been made against him. So the third respondent, that is. So we also want to hear. And apart from that, also the elephant in the room is the report that will come from the team that was tasked to look at the server. The server. Yes. So was it a wild goose chase, or there was something to hide?
All right. Your closing comments, very briefly.
Thank you, Michael. For me, I'll say this about the Supreme Court and the ultimate decision they have to make. Given the way the Supreme Court has conducted itself, given the way it has accepted the applications and everything else, at the end of the day, when they come up with a judgment, which they have assured us that it will not be a 5-minute like the 2013, that is a judgment that we ought to live with, because they have indicated, and you've seen it manifestly, that they are keen on dispensing justice, regardless of where it lands. And in my view, if they proceed that way on Friday, whatever judgment they'll be coming up with, I think, and I dare suggest, that it is a ruling, it's a decision that we Kenyans, from both divide of the politics, ought to live with and say, hallelujah, let's move on. It's one country.
All right. Thank you very much, gentlemen. Dr. Mukhwana, Collins, Mango, and Martin Olo for joining us this morning and breaking it down on what is happening at the Supreme Court and also what we should be looking forward to. This is the early edition of Kivumbi 2017. We want to take a short break, but we'll be right back with news that are making headlines both locally and internationally. Do stay with us.
Thank you.